Yesterday we discussed compounding of an offense, section 320, and today section 321. Compounding of an offense means where the party themselves are coming to terms. They have made the settlement. But as we know, in the case of criminal cases, the case is prosecuted by the state generally. That once the case has been prosecuted or initiated by the state, now the question is, can state withdraw from that prosecution? The case is prosecuted, initiated against an accused, and after some time, if state thinks so, that the cases pending against this or these accused should be withdrawn. The answer is yes. And you may have heard so many times the political controversy with regard to the withdrawal of the cases against some political personalities. A particular governments come. It usually happened at the time of the changing of the government. Some cases are withdrawn against some people. But there is one rider. If that rider would not have been there, in that case the position would have been entirely different. The state, according to its choice, might withdraw cases, pending cases, against the person of their liking. But there is some rider. What is that rider? In a way, we can say there is a restriction. What is that restriction? State can withdraw the case, but with the consent of the court. With the consent of concerned court. Concerned court means the court in which the case is pending. If that court itself consents, in that situation, a case can be withdrawn by the state. You may have heard about an infamous controversy. That controversy was related to the Phulan Devi. A dacoit of Phulan Devi, after she became an MP from the Samajwadi Party. Okay, she surrendered. After the surrender, obviously there were so many cases pending against her. And all those cases were being prosecuted in the different courts in different districts. During the Mulayam Singh regime, she was given a ticket and thereafter became MP. And after some time, because it is the state subject, Mr. Mulayam Singh government wanted to withdraw all the cases pending against her. Applications were filed for the withdrawal of the prosecution, but none of the case or the court did not consent. Therefore, no case was withdrawn or could be withdrawn against her. It was just because of that rider, that restriction, that the case can be withdrawn, but with the consent of the court. And the consent of the court obviously is subject to the judicial mind. It depends on the case, circumstances of the case, etc., etc. Or in a way, we can say that it is a matter of judicial discretion. It is section 321. Withdrawal from prosecution. The public prosecutor or assistant public prosecutor in charge of a case may, with the consent of the court, and obviously the public prosecutor, assistant prosecutor means the state. They are the state. They are the government official. Okay. Obviously, the application is filed by the prosecutor and the public prosecutor, assistant public prosecutor, but it is a step taken by the government, state government. At any time before the judgment is pronounced, at any time during the trial, before the pronouncement of the judgment, withdraw from the prosecution of any person either generally or in respect of any one or more of the offences for which he is tried, and upon such withdrawal. And what is the result of that withdrawal? For example, if a case is being tried for an accused, either he is acquitted or convicted. But what is the position of withdrawal? Or what is the status of that withdrawal? Many a times or if you have not seen, you will see in so many forms, employment forms, you will find a column. Have you ever been convicted? Yes or no? So that is the importance of conviction. So this clause also clarify what is the status of an accused in the case of withdrawal. What is that? If it is made before a charge, the case is before the court, but the charge has not been made yet. If it is made before a charge has been framed, the accused shall be discharged in respect of such offence or offences. In that case, if the charge has not been made, charge has not been framed yet, if during that time that case is withdrawn, that means the status of that accused will be that he is discharged. Second, if it is made after a charge has been framed, or when under this code no charge is required, he shall be acquitted in respect of such offence or offences. If the case is withdrawn, that means the status of that accused will be equal to an accused who is acquitted, or it is equivalent to acquitted. In that employment form, we can write, anybody can write, have you ever been convicted? The answer will be no. In the cases of withdrawal, there are some more conditions, provided that where such offence was against any law relating to matter to which the executive power of the union extends. It is about, for example, generally it is the state subject, but there are certain laws where the union law is applicable. For example, in the cases of CBI cases, CBI acts under the Delhi Police Establishment Act 1946. It is controlled by the center. Suppose if the case is withdrawn by the CBI etc., etc. In that case, in other cases, state means state government, but in such cases, the state means central government. That's all. It was section 321. After 321, the last section of your CrPC, not last, there are 482 or 484 section. Uh, Section 482, that is about inherent power of High Court. Saving of inherent power of High Court, section 482, very, very important section. Important section in many terms. And also it is one of the sections which is the biggest contributor in the pendency of the criminal cases. It is one of the main reason that we find so much pendency in the criminal cases. Let me first try to understand what is inherent power, what are inherent power. Inherent power, we know our CrPC is very lengthy. Legislator have almost tried to incorporate each and everything in the CrPC. Yet, despite of that, it is near to impossible to incorporate each and everything in a procedure code. Now, suppose if a situation arises, what we will do, what the code will do, code will look into the CrPC to resolve that situation. What is the provision about that? If there is a provision, it's okay. If there is no provision at all, in that case, in these special circumstances, the inherent powers are given to the High Court under section 482. The inherent power means the powers other than vested in the CrPC. It is something which is contingent. It is something which is about the future. And if there is no provision in the CrPC, it has the power of the High Court. The High Court has the inherent power to resolve, to solve that issue, that situation. The inherent power means all the powers other than the specified powers are inherent power. That's why one of the famous judges of the Allahabad High Court once said, these are not the inherent power of the court, High Court, but these are the power inherent in the court. As they are the High Court, these power are inherent because it is their duty to correct the lower courts. So this is the inherent power, but in addition to that, there are two aspects of the inherent power. One, as I told you, if there is no provision, there is no specified provision, the High Court can use inherent power. But the other aspect is if there is provision and that provision is being misused by the lower courts, lower authorities, or the process is being misused. The second aspect is the High Court can correct that misuse of the power by the lower court or the authorities. Okay, as it says, and it can be done for two things. Okay, and it is done for one of the important thing. The logic is that the High Court there should not be injustice. If the High Court thinks that by this act, by this thing, by this misuse of the process, some injustice is being done. In that case, Section 482 provide these wide power to the High Court to correct that injustice. So I am reading the language of Section 482. It is very small sections, but widely prevalent, widely used section. And I will just tell you how it contributes in the pendency. It says that nothing in this code shall be deemed to limit or affect the inherent power of the High Court to make such order as may be necessary to give effect to any order under this code or to prevent abuse of the process of any court or otherwise to secure the ends of justice. Ultimately, the code work is to bring the justice, to serve the ends of justice. If anything, according to the High Court, is considered as it is not in favor, it is necessary to secure the ends of justice, the High Court can use this power, and obviously these powers are given to the High Court. These powers are not available to the Session Court or any other court. Okay. For example, FIR is lost. For example, protest petition is lost after submission of the charge sheet. As we know that there is no essay specific provision for the protest petition. It is based on, it is developed, this concept developed on the basis of the different ruling of the High Court. Now suppose if other party wants to go against this protest petition, what is the first thing? The first thing is that he has to look, that party has to look into the CrPC, where is that provision? And he will not get that provision. Why? Because even the provision of protest petition is not there. And he considered, that party considered that a certain injustice is going to be done. So he can approach to the High Court under the inherent power. Suppose an accused, a summons are issued to an accused under section 319. 319 is where the accused can issue a summon to any person who is not in the FIR or the charge sheet, etc., but the court thinks that this person is relevant in this case, he may send a summon. Court may send a summon to that accused. Whenever you have got that summon, and obviously the Getting a summon means it doesn't mean that the court has invited for a dinner, for a lunch, or for a tea. Getting a summon or warrant means the very first thing which that person who has got someone under section 319, what he has to do, the very first thing has to be done by him, that he has to get bail. Issuance of summon, it is not just like an invitation by the court. It means come to the court and the first ensure your presence, future presence in the court. How that is ensured? That is ensured by the bail. And thereafter the court will hear. Court will tell the reason. Court will ask the question, why you have been called, why you have been summoned here. But it is not just like this. The summons are sent and the person comes in the court and explain and free to go. No. And that's why whenever someone as an accused comes from the court, it is very a serious thing. Now, if somebody has got the summon under section 319, the entire picture coming, rotating in his mind. What is that? Now I have to go to the court, I have to seek bail, and there are so many things. And on the other hand, I am innocent. I have nothing to do with this case. Of course, the reason is written in the summon. He looks in the summon and is of the view that I am no more relevant, I am not relevant at all with this thing. Now, what to do? There are two options. He should go to the trial court and should explain his position. But it is not so easy. For that, as I told you, that he has to get the bail. He has to bring the surety and this and that, etc., etc. The bail means many restrictions are imposed on you. The other option may be that he may approach to the High Court under section 482 without going to the session court. He may ask, he may plead before the High Court that this is the summon, I have no connection with this case. Despite of that, I have been summoned by the lower court. It is just a misuse of the process, misuse of the power given under section 319. This is inherent power of the court. Now the High Court, what High Court can do? High Court may outrightly reject, may say that you just go and face the trial. If you are innocent, you have nothing to do with the case, obviously you will be acquitted. Second, the High Court will quash the summon order issued by the trial court. May quash. No, you are right. You are unnecessarily being summoned by the lower court. we are satisfied. High Court will say, okay, High Court is satisfied with your position. Okay, it is quashed. Issue is over. After that quashing order from the High Court, that accused need not to go to the lower court, which rarely happens. The third situation may be the High Court can say, okay, you seem to be correct to some extent, but we are not in a position to give a final judgment or to decide it finally unless we hear the other side, we hear the position of the other side, this, that, etc., etc., etc. What we do, we just stay your summoning order. Stay order is passed by the High Court and the date is fixed. And whatever court considers it, court issues the notice. Obviously, the other party will file a counter affidavit. After that, the rejoinder, etc., etc. And this matter goes very long. It is a long-lasting process. Now, the important thing is this: if the stay is granted by the High Court under Section 482, and it is not about only about the Section 319. It may be for any process, any provision, any section, anything in the entire CRPC. When the stay is granted, that the proceedings which is going on in the lower court, that will come to a halt. Stopped. It is stopped unless the final decisions come from the High Court with regard to that application which was filed under Section 482. So in this way, the pendency is multiplied. The case is in the lower court, and the something somewhere from somewhere, and parties and the advocates know all these techniques. They immediately suggest that to go to the High Court under Section 482. If the somehow stay is granted, everything comes to a halt, stop, and it is the parties and the relevant party or concerned party wait for the judgment or the decision of the High Court, which obviously takes a very long time. In this way, I saying that the 482 is one of the biggest challenge. On the one hand, it is necessary that if everything which is wrong, just a second. And it is not, it is in so many, not only for section 319, person can go under section 313, 311, etc., etc. Okay. After section 482, yes, any question up to here? Are you there? Are you people there? Anyway, the last section of the last class, that is section 468, limitation. In criminal cases, so far as the limitation period is concerned, it is not much relevant as it is in civil cases, and that's why we have the separate act for the civil cases, the Limitation Act, which tells us in which type of case, what is the time limit to approach to the civil court if there is a case relating to immovable property. What is the time limit from the date of the cause of action one can approach to the civil court? And it is very, very important in civil matters. But in criminal side, except few cases, as such, there is no limitation period. For example, you must have heard about the Sheena Bora case. It was somehow related to even to Guwahati also. She was murdered in 2009 and the FIR was lodged in 2015. Cognizance was taken by the court in 2015. So there is a very simple rule with regard to the limitation, which is provided in section 468. It says that if there is an offense where the punishment is only a fine, in that case, the limitation period is 6 months. Court can take cognizance up to 6 months. Not more than that. If suppose if there is a punishment, there is an offense and the punishment is the fine is only fine, and the person concerned comes before the court after 8 months, the court will not take cognizance. If there is a punishment up to 1 year, there are many offences where the punishment is up to 1 year. In that case, the limitation time to take cognizance by the court is 1 year. After 1 year, no. Court cannot take cognizance. Right? If the punishment is from 1 year to 3 years, in that case, the limitation period is 3 years. Suppose if there is an offense of the theft, where the punishment is up to 3 years, the court can only take cognizance within those 3 years. If they come before the court after 3 years, 4 years, and 5 years, court will not take the cognizance. And if in any punishment, if there is any punishment more than 3 years, more than 3 years means it starts from 3 years up to the maximum punishment. And what is the maximum punishment? Maximum punishment is the death penalty. In those cases, there is no limitation at all in the criminal cases. Court can take cognizance at any time. That was the reason because it was the case of murder, Shinagoda murder case. Therefore, the cognizance was taken in 2015. If there is a murder, no time limitation. Any offense where the punishment is more than 3 years, no limitation period for taking cognizance by the court. And this is the reason if sometimes you hear the cases which are very old cases, all of a sudden comes, criminal proceeding begins. But this is not the position with the civil cases. In the civil side, the limitation period is strictly followed. And one more interesting thing, in some cases, for example, it was a time very everywhere we were seeing about the campaign, the very famous campaign. What was that? Me Too campaign. Me Too campaign. It began from somewhere from USA and widely prevalent, became very famous in India also. And there were many cases appeared which were very old. All of a sudden, did you know about this? Yes, please, anybody? Anyway, okay. Uh, at a time when all this campaign was going on, and it was becoming the headline news in the newspaper and the particularly in media, and it was looking like this. Okay, now these people are going to be punished very soon, are going to be hanged. And it was the feeling that now we don't know what is going, what is going to be, or all these people will have the very dire consequences. But if I ask you, where is that campaign today? Do you hear something about that campaign these days? The intensity which we observe, it was a particular time period, and just realize the intensity of that campaign. But we don't hear anything about that campaign right today, these days, except a few cases. A few cases are going on. What is the reason? The reason was, okay, you have filed the FIR, that's okay. FIR can be filed anytime. But when the matter comes before the court has to see. There are many rules, so many rules with regard to the taking the cognizance, taking the judicial notice of that case. When all these cases reach to the court, they could not stand up before the court because in many cases the cognizance was not taken by the courts. And reasoning was so simple. So what is the punishment? And when are you coming to the court? Where have you been for the last many years? If something wrong has done to you, you should have approached to the court. That's why your case does not stand before the court. The court is not going to take the cognizance of these cases. Okay. The cognizance by the court is very important with respect to the time period, but it is in criminal side in maximum cases, or we can say in the serious and grave cases, there is no as such time limitation, but there is limitation up to 3 years. In case of fine, 6 months, 1 year, 1 year to 3 years, 3 years, and more than 3 years, no limitation. That's all. All the best. Your examination date has already been announced. My mic is not working. Yes, please. What? Just a minute. I could not see. Oh, attendance. UID 6. Just a minute.